Constitution Society. I want to thank Rachel for making this happen. But I'm happy to introduce our speaker, and we'll say why in a minute. In addition to that, he's a well-known constitutional law and jurisprudence scholar. His principal appointment is at the Catholic University of Argentina in Buenos Aires. That's where he got his first law degree. He then studied at Oxford under John Finnis, the very well-known legal philosopher and natural law theorist. He then returned to Argentina, got his PhD from the University of Buenos Aires, or all these. This is the English translation of all those universities, and his appointment. Clerk for the Argentine Supreme Court, and then went into law teaching. He's been a visiting professor at several times at Notre Dame Law School in Indiana, also at Strathmore Law School in Nairobi, Kenya, and visiting lecturer many places around the world, recently at Harvard, and now today at Cornell. But I met him at none of these places or any of these continents first. It was at a couple of conferences a few years ago in India, both at Jindal Law School, a conference on globalization and law, where, among other things, my daughter Weatherly teaches, and then at a separate conference down in Mysore in southern India, and found Santiago to be just sort of most engaging and thoughtful and true public intellectual. So I was delighted when we were able to invite him here, speaking on the natural theory. The title does not have the word natural law theory, so I'll just describe the title. Natural theory of comparative constitutional law. So please join me in welcoming Professor Legarre.
Thank you, Dean Schrapp, Stuart, for that very kind introduction. I indeed spent some time, actually only maybe 2 days in India with him and 2 of his children, and we were reminiscing today in the morning that I learned so many things in 2 days. Like, for example, I remember his saying to me, although this has nothing to do with comparative constitutional law, by the way, that a person who hasn't missed a flight in his or her life doesn't make good use of time. So after I met him, I actually did miss a flight, and I actually don't think I now make better use of my time. It wasn't a very good experience, but anyways, thank you. Lots of wisdom out of the law from my friend Stuart. Rachel, thank you so much, and the American Constitution Society as well. I arrived last night like an hour and a half late. I thought it was because of the storm, but it was also because there was a diversion. We had to take a detour, and Rachel and Pete were there waiting patiently. Like, this is like almost midnight. Let me start by mentioning yet another trifling, banal thing, which is the video that American Airlines is playing these days with safety instructions. So I've taken like 4 domestic flights before I came here, and even one from Argentina, and now the enthralling voice of the new American Airlines lady who speaks in the video is always in my mind, and she starts by saying, first things first, let's buckle those belts. Like with charm, not the way I would do it. And why don't I, first things first, tell you what natural law is not for the purposes of this question mark that was flying around the screens of the building today. Question mark, a natural law theory of comparative constitutional law. So first, natural law is not what Dr. Strange breaks consistently. That is Benedict Cumberbatch in the new Marvel feature Doctor Strange. He likes to mess with time, and he has a tool where he would turn something in his wrist and manages to break the natural laws. And then there's this guy who is like a librarian there somewhere in Kathmandu or something like that, who says, please respect natural law, don't break natural law. And then this guy by the name of Wang presents himself as a guardian of natural law. Well, this has nothing to do with natural law in the topic of my talk, but it's important to clarify it because many times people reasonably think that if you're talking about natural law, then you think gravity, you think snowing, you think time. So don't mess with natural law means, don't try to upset time like in Doctor Strange. Perhaps to avoid confusion, we can refer, as some people do, to those as natural laws in plural, the laws of physics, the laws of chemistry, whatever, you name it. These are laws where human freedom really doesn't come much into play. So if you jump from the tower where I'm staying here, a 6th floor, you will fall, regardless of, if you say, I don't want to fall, you will still fall. Not so with natural law, the one in the title of my talk, because this one, as opposed to natural laws, is more like an invitation that can indeed be broken without the need of a magical tool like Doctor Strange. You merely decline the invitation to act in the morally right way natural law invites you to act. Now the idea that freedom is very important when it comes to natural law in the classical sense, the one I'm using today, is not mine, of course. I mean, this is the sense in which Plato and Aristotle, mostly without using the term, would refer to the concept of natural law, and then the Stoics, Thomas Aquinas, etc., using both the term and the concept. This is what I am referring to. The idea that freedom is an inherent part of this natural law is something that natural law has in common with religion. Religion being the second thing I'm not going to talk about. So natural law is not natural laws, and natural law is not religion. Although sometimes people think that these are the same thing, because a saint, say Thomas Aquinas, would talk about natural law, and therefore whatever a saint would say ought to be a religious thing, which obviously doesn't make much sense if you think that whatever a saint is for you, if he performs medicine or jumps from a 6th floor, he will act similarly as someone who is not a saint. Nevertheless, as I said, when it comes to religion, the way most religions are understood, freedom has a significant role, and typically the worshipper can resist God in most religions. And in that sense, religion is different from natural laws and similar to natural law. However, it has a very important difference with natural law, and that is that religion is, generally speaking, revealed by a God, and therefore it requires on the part of the agent something that typically goes by the name of faith, none of which is in place when we're talking about natural law. That is, you can actually understand the invitation to do something that is presented as morally right, say, for example, not to take the purse that you find in the library on a chair next to you, and you notice that there are a couple of $100 there, and then you more or less perceive this whisper, don't. Well, you don't need to believe in God to have a faith to understand that that is wrong, if what I'm saying is correct, that is. Again, nevertheless, the contents of what is morally right under the description of natural law oftentimes overlap with the contents of some religions. And famously, for example, some of the Christian classics, to summarize natural law to their pupils, they would explain that you can sum them up thinking of the Ten Commandments of the Old Testament, of the Torah, of the Jewish faith. So they would say, thou shalt not kill, for example, is both a religious precept for a believer, but then it is also a natural law, moral precept that comes to you by way, again, to use the analogy of a whisper that then you need to decide whether to accept or to decline. Finally, on buckling and first things, natural law in my talk is not what U.S. Supreme Court case law refers to under the term natural law jurisprudence in some highly discredited cases, such as, for example, Lochner. That meaning of natural law is circumscribed to the jurisprudence of the U.S. Supreme Court, whereas this is a very universal, as we will see, idea dealt with in philosophy and in ethics, and not so much in constitutional law. Right. I will now move further after this initial denial, like 3 denials, to try to characterize briefly what I will mean by natural law for the purposes of comparative constitutional law, because later I will suggest that natural law provides a solid foundation for the comparative constitutional enterprise, and indeed, in general, for comparative law. But it won't be, of course, my goal here to go deep and try to persuade you that, this is it. For that, you may perhaps want to read other works that are on natural law. For example, Stuart mentioned that by Professor Finnis, who was my supervisor in Oxford. His most important book on this is called Natural Law, Natural Rights. Or you may want to read Plato or Aristotle, or maybe you did already, maybe you agree, maybe you don't. Myself, I've written on the topic, and I've dealt with more detail than I will do today in a paper published precisely in the Strathmore Law Journal, the law journal for this Nairobi-based law school that was mentioned earlier. So I suppose the first idea when it comes to try to explain in a very simple way what is natural law is the idea of universality. And universality, if you think of it, has a temporal dimension and has a spatial dimension. So the claim here is that there are some moral norms that are the same everywhere, and that have been the same in the past, they are the same today, and they will be the same in the future. It's quite a claim, but again, it's not an original one. This is what Antigone would argue in her crucial discussion with her uncle, Creon, as related by Sophocles before Christ in his play Antigone, precisely, where she had broken a positive enactment by Creon, which said, as you remember, that she couldn't bury her brother because her brother was a traitor, and she nevertheless went ahead and did, and when she is having this very heated discussion with Creon, she says to him, my laws, she calls them the laws of Hades, she doesn't use the Hades as in Percy Jackson, she doesn't use the term natural law. The term natural law, as I said, comes later in the terminology, philosophical terminology. The laws, she says, that I followed are not from Thebes. They are the same in Athens, in Thebes, one could say in Ithaca, as well. And then she says, but she actually does say Thebes and Athens. And then she goes on and says that unlike your law, uncle, this law, the one that requires me to bury, to honor my brother, was always there. You know, it wasn't enacted by someone like last year. So firstly then, universality, temporal, spatial. Secondly, the idea that the core content of natural law is objective. This is like the key word to contrast with relativism. The notion that indeed you may think that you ought not to torture someone, but that cannot be asserted as something objectively wrong. It is just your view, then there is a person who has a second view and maybe a third, and they all have similar value. They are all just subjective claims. There is no such thing as right and wrong. Instead, natural law says exactly the opposite. There are such things as right and wrong, independently of the utterances of moral agents. This, of course, is tied with the prior idea of universality, spatial, and temporal. And thirdly, moral natural law is incomplete. It doesn't fill up all the gaps that need to be filled up in order to provide for a flourishing community, for a flourishing individual life. In other words, moral natural law requires what you have come to study here at Cornell Law School. Law. Law, positive law, human law, as the theorists of natural law would call it, is a necessity from the point of view of natural law. Natural law is not there to replace positive human law, but rather moral natural law is necessitated of the complement of the concretization of laws, of the given laws of the different countries, different communities, even smaller communities. Even a university will need a positive human law, a club, etc. In other words, that whisper that suggests as right or wrong conduct only suggests as right or wrong some conduct. But then there is a vast camp, field of conduct that will only become wrong after a given positive human enactment declares it wrong. And the same with right. This is why, surprisingly for some people, natural law is not an enemy of many forms of so-called positivism. It was always thought otherwise, you know, that positivism is like the great enemy of natural law. But insofar as positivism defends the positivity of human laws, ironically, both natural law theory and positivist theory are on the same side of a divide. Now, on the other side of the divide, you find what is taught today in most American law schools when it comes to jurisprudence, which is, under different names, that the law doesn't exist. You know, there is no such thing as normativity. What there is my feeling, or my feeling of economic efficiency, or my feeling of social justice, or Marxist justice, or libertarian justice. There is a norm that says so and so. Well, that doesn't really matter so much. For the judge, you know, norms, they can be interpreted. There's always room. So what matters is to be fair here, and fair is what I find fair. You know, this is like really far from natural law, and close to, for example, also natural law jurisprudence, to some forms of critical legal studies, to some forms of economic analysis of law, Marxism, etc. So all these views, in one way or another, they compromise the positivity of law, and they actually make the very idea of studying law more or less senseless. And this is perhaps why there is so much law and, you know, because you want to know all the other things, given that you're going to, anyways, get rid of the law in order to do justice, so to speak. Well, what are the goals of positive law according to natural law theory? I would summarize them in three. What is law therefore? Well, first, as I said earlier, to complete, to concretize natural law, to fill all those gaps. You know, natural law tells you that torture is wrong, but it doesn't provide for a given punishment, years, etc. Natural law tells you that if someone goes bankrupt, there has to be fairness in the distribution of the property among the creditors, but you need rules for that. There enter bankruptcy law. Natural law tells you that you ought to keep your word when you agree on something, but there are all sorts of contracts, and you know, and there comes contract law and torts and property and so on and so forth. Secondly, positive law has the role of promulgating natural law, so that no one will be able to say, hey, I didn't hear any whisper myself. You know, that can happen. Imagine a little kid who is brought up in a community where they teach him, I don't know, cannibalism, or they teach him that stealing, this is the mafia community. Well, now the person will not be able to say, well, you know, I didn't know. Well, there you have the positive law that tells you what you ought to have done. And thirdly, the positive law provides something that the natural law has in an imperfect way, and that is, it threatens you that if you don't do that, whatever it is, you will have some kind of sanction, some kind of punishment, and then gives the details for the punishment. Now, Antigone says to Creon that she will indeed receive a punishment if she breaches the laws of Hades, natural law, that is. And that punishment is, of course, conscience, your conscience that will tell you, you know, you've done the wrong thing. And in that sense, that sanction is even worse than the punishment by positive law, in that you won't be able to escape it ever. You know, wherever you go, your conscience will go with you, telling you you should have buried your brother, or whatever it is. But still, for community purposes, it is of course necessary that we have more concrete sanctions that will dissuade people from breaking the law. I would end up this first part of the talk by pointing out to two benefits, as I see it, of incorporating natural law into the analysis of law, and even into law school. So when I teach jurisprudence, for example, part of the class is precisely about this. The first one is that natural law allows you to better understand positive law, because in most positive laws there is a core of morality. In some cases it is more apparent, criminal law, human rights law. In some others it is less evident and more, as Justice Breyer would call it, we will see later, more arcane areas or parts of the law, which I think amount to 95% of law and what one studies in law school, which is why I think that if a person really likes natural law very much, that person shouldn't study law probably. Instead, typically in my view, you may of course disagree, someone who has a more of an engineer kind of mind, that person is probably better suited for law, where you will have to deal mostly with highly technical things that where morality is present, but the presence is quite remote in most areas of the law. Secondly, natural law theory allows you to criticize positive law and to hold a given enactment, for example, as unjust. It only makes sense to say that a given enactment is unjust if you're doing it from a point of view that is detached from the, so to speak, inner normativity of the law. And natural law provides precisely that. And indeed, one chapter of natural law theory, the best known chapter and the least important one, is unjust laws, what you do with an unjust law. And famously and sadly, some of the natural law theorists have said that an unjust law is not a law, and this is the only thing that people know about natural law. They only know something that indeed is not really true, because if I say, as I borrow from Finis here, that unjust laws are not laws, then of course I'm saying that they are laws. But that's part of the talk I'm not giving. So I move now to comparative constitutional law. I would like to divide the topic of comparative constitutional law in three: academic comparative constitutional law, legislative comparative constitutional law, and, more importantly for our purposes, judicial comparative constitutional law. Academic. So, this is books, writings, lectures like this one on comparative constitutional law. What is there regarding this? I remember when Stuart Schwab, who introduced me, presented in Jindal, he told the audience that when he joined Michigan Law School, I suppose in the mid-80s, a long time before he was dean, which as you know he was until 2 years ago, there were 8 courses offered here at Cornell Law School on comparative topics. But in 2013, when he was giving the talk and when we met, there were 30. So from 8 to 30, just to give the example of the school where we are now. That meant, he said, that 20% of the curriculum of Cornell Law School in 2014 was comprised or had some comparative component into it. In 1948, the AALS, the American Association of Law School, decided to start paying a special attention to the teaching of comparative constitutional law. There was a big event that year of some institute whose name I don't remember now, and the AALS sponsored this activity. This was like a great move, to think that there is this idea that in the US we aren't interested about what's going on elsewhere. We are insular, we were British, some. We are provincialists, say some. But then, from the 50s, there is this change, slight at the beginning, huge later. If you want to get a feeling of where things were standing in 1950, for example, I recommend that you read an article in the Columbia Law Review by Stevenson, titled Comparative and Foreign Law in American Schools, American Law Schools, where, among many things, he says that then, in 1950, there were already 26 US law schools that had some form or other of comparative law. 26. Right now, maybe they are 260. In 2001, the ALS detected that the fastest growing area in the curricula in all the law schools was comparative law. So there is this in the academic field, and what we will see later in the judicial field, the one that is more relevant for us today, surely has something to do with those professors teaching future Supreme Court justices. So now they are in the court, now they are Breyer, etc., and they are doing the judicial thing. But before, let's talk a little bit about legislative comparative constitutional law, which includes both the work of an ordinary legislator, say Congress, and of an extraordinary legislator, say a constitutional convention, for example. So here it's quite unproblematic, not controversial, that such a legislative body can and in fact ought to borrow, to look at what's going on elsewhere before they make a given law. For example, Waldron, in a seminal article in the Harvard Law Review in 2005, he says, if you have in your country a given epidemic, and you know that in some other country they've dealt successfully with the same epidemic, then it makes total sense to study what happened there and try to use it. So I think this idea is very useful to understand legislative comparative constitutional law, because there you are basically unconstrained. The legislator is not constrained by existing law. In general, the legislator can remove existing law by new law. So if he wants, or if the body wants to do it, can look into foreign law in order to find better ideas. You still need, though, to have a reason to do that, because otherwise it would be a total waste of time. Why now leave the epidemic example aside? Because there it's obvious why you're going to look at it. But if you think of law, why will you waste your time studying the systems of, say, how you legislate euthanasia in Europe before you say Europe, for example, before you legislate here in the United States? So if you need a why, then the foundation that I will offer when I finish the lecture is also, or I think can be also useful for legislative comparative constitutional law, and not only for what I will touch upon next, judicial comparative constitutional law. So my conclusion will apply to both, and indeed, of course, to academic comparative constitutional law. Otherwise, why would someone study, teach, etc., if there isn't a point, if it is a senseless adventure? So we need to give it some sense, and that's what I'll try to do in the end. Judicial. This is better known. You know the cases: Atkins, Roper, Lawrence, Graham versus Florida. You know perhaps that this was all very boosted by a debate that was broadcasted by C-SPAN and made the front page of the New York Times in 2005. This is Scalia saying that this is a bad idea. You know, it's a total waste of time. It's pointless. It's irrelevant. It's against our law, etc. And Breyer saying, well, he says something that I find very funny, being myself from Argentina. He says, Americans are human. Bingo. And therefore, if they are human, they share problems with other human beings. And this is why he says, this is like his starting point to explain why in some areas of the law that are more human, say human rights law or the fundamental rights parts of constitutional law, it makes more sense, he says, the comparative enterprise than when it comes to what he calls more arcane, technical, obscure areas of the law, where the odds that you will learn something from your foreign brother and sister are lower, because this is way more contingent and variable. We go back to Antigone by way of contrast. So in Atkins in 2002, there is a footnote, number 21, and this footnote, where there is an insinuation by Justice Stevens that we're going to embrace the idea of studying, at least in some cases, foreign law to illuminate our decision. This explodes and gets into a lengthy section of an opinion 3 years later in Roper versus Simmons. Both are capital punishment cases. One has to do with mentally retarded people, and the other one with juvenile delinquents, as you know. This section 4, the ideas there were embraced later in 2010 by Justice Sotomayor in Graham versus Florida. So she's also happy with this comparative constitutional enterprise. And by way of contrast, Justice Alito, who was not there to dissent in 2005, he did join the dissents by Justices Scalia and Thomas, again in this same case in 2010, Graham versus Florida, where Sotomayor made her first appearance on this topic. What's the theory there in Roper versus Simmons by Justice Kennedy? I would summarize it in 3 ideas. The first one is that comparative constitutional law doesn't control the decisions of the court. It only offers what he calls a confirmation, a confirmatory role. Confirmatory of what? Confirmatory of the reasonableness of what we're doing. Now we need to be very careful, as Justice O'Connor points out in this case, not to rationalize, not to manipulate, and not to substitute a given law that we don't like for a foreign law that we like better. That wouldn't be confirming what there is, that would be changing what there is. And that's not what comparative constitutional law is for, according to the Supreme Court, to the majority of the Supreme Court, and I agree with that. Secondly, I say, reading in between lines, Roper versus Simmons and the other cases, it has an educational role. It instructs me about my own law in the same way that if I study English, I can understand Spanish better. I was at a lecture, by the way, in Notre Dame last week by Professor McIntyre, where he made the very bold claim that someone whose native tongue is not English, but speaks English plus his native tongue and some others, is better equipped to read, say, the Ulysses by Joyce or some difficult books in English than a native speaker in English who doesn't speak other languages. Well, whether this is true or not, I would like it to be true, of course. It is interesting to explain why looking outside can help us better understand what we have here. And finally, the role of comparative constitutional law always ought to be obiter dictum. It will be a dictum or several dicta in a case, so to reiterate, it ought not to control. You may think this is a slim theory, but it's very much rejected not only by the dissenters in these cases, which reject the slim version even, because they think it's totally unnecessary, dangerous, irrelevant, pointless. But then there are many other people who think the same, for example, Judge Posner. And therefore I feel in the need, and I would do it anyways, to provide, to offer the Supreme Court, as if they wanted it, justification to do what they did. At least it would be a justification for me to write about this. With which I enter the last segment and the last 5 or 10 minutes of the talk, and then I'll be happy to answer questions if there are any. how is it that natural law comes in? So we go back to the beginning of the talk. Well, remember universality, human rights are said to have a universality. Firstly, a sociological universality in that, with some exceptions, there is like a general acceptance that certain rights, the core of certain rights, of course there are discussions about contours and about some rights, they are everywhere, they're almost everywhere. But then also, and more importantly, a normative universality. In other words, that this ought to be so. When by exception a regime suppresses universality, is acting against this normative dimension of the universality of human rights, universality that they borrow precisely from the universality of that critical objective morality that I called earlier natural law. Natural law, it ought to be understood, and now I should make it very clear, natural law under whatever name. You see, it may well be that you agree with all I'm saying and you call it differently, in which case we would be in agreement. Or it may be that you are very happy with the word natural law, but you mean otherwise, in which case we are in disagreement. For example, I have a colleague in a body that gives grants, and we need to decide which grants go and which don't. And we were talking the other day, and she's a relativist, she's a Marxist, she's a great person too. But she was saying to me, yeah, that was fine. She was saying to me, I really like natural law. I love it. I noticed that you have this book that says natural law. That's what I like. And I said, great, great. But I thought, we are in disagreement. I mean, she will still be my friend. Now we know she will still be a good person. But if she's a relativist, as she is, if she thinks that there is no such thing as right and wrong, then it's not natural law what she's talking about. So the names are not what matter, really. What matter is the acceptance of, the description I offered you earlier today. I think that this idea that there is a universal objective morality with all its shortcomings in a world like ours, with so much fragmentation, with so much skepticism, it's still the only way to go about doing comparative constitutional law. If you embrace relativism, as I would say most scholars who do comparative constitutional law do, then I can't see the point of looking abroad. I mean, what are the odds, if you don't buy into universality, that there will be the reiteration of patterns and of moral patterns? Just be a nationalistic type and, just assume, as the sophists would, that law is only a matter of whim, of sheer will, that there is nothing of reason there, and therefore nothing reasonable or unreasonable. And if you do that, you ought to do what Justice Scalia said. Just look at your own law. That's the only thing that matters. The rest is a waste of time. I obviously disagree. I think it's a very promising, very worthwhile enterprise. It's, of course, full of traps, full of complications. Maybe some of them will come in the Q&A. Still, someone who manages to find a solid ground, and I think this is solid ground, can go far into reaching some conclusions when it comes to doing comparative constitutional law. Thank you.
Anybody have any questions or comments?
Yes.
Can you just rephrase the point you made about the relationship between active law and natural law? How they play off each other?
Sure. Any particular aspect?
Were you saying that positive law helps to codify natural law?
Okay.
Okay.
So I'll take advantage of your question to fill a gap in the lecture. There are, broadly speaking, two types of positive laws, or to be more precise, in a given legal system, say the legal system of New York, of the US, doesn't matter. There are two types of norms, of precepts. Even in one very same article or section, there can be both. Let's call them A and B. So A, which I argued amount to a very small proportion of the totality of the norms in any given legal system. A, relate, connect to natural law in a straightforward way, very direct. What A does is almost merely to repeat, but it's not quite that. It ratifies positively what was already wrong morally. So say, for example, the law of theft. In its core, what it does is merely to rephrase what was already there. You ought not to steal what is not yours, or you ought not to steal, rather. Then there's B, which I argued makes us engineers. When a precept is the B type, then that precept has such a connection with moral law, with moral natural law, that you will need to explore to find it. It's not there on its face. So, for example, to go back to an earlier example, you are studying bankruptcy law, and in the surface, this is a very technical thing, but if you want to understand the rationale of the surface, you dig deeper and you understand how this given precept that tells you to give X to creditor A and not creditor B has a rational sense in itself, is inherently reasonable, or at least not unreasonable. But unlike what happens with theft, this isn't like clear like this. Does it help?
No, that does. Thank you.
Yeah.
I know in the beginning that you said that natural law isn't religious law, but it is necessarily very entangled with like Catholic teaching and Catholic morality. And so I'm wondering if in appeals and application of natural law, there's a danger for judges to just apply the familiar or apply religious rules when they're handing down sentences if they're looking to natural law for guidance.
Yes, I think there is a danger. There is always a danger for any judge to let his or her religion control. It would be analogously, to let foreign law control. You ought not to do that with foreign law. You ought not to do it with a law review article. You ought not to do it with your religion. Or anything, actually. But the truth is, natural law is a reality and a concept that pre-exists the Christian religion, so much so that, for example, you have great scholars of Judaism writing on natural law. Myself, in case you're interested, I wrote an article titled Natural Law in Judaism Revisited, which is, more importantly, a reference to a book, a whole book called Natural Law in Judaism. You won't find any references to Catholicism there. If you read Aristotle, writing in the year 330 BC, of course you won't find any references to Catholicism or Christianity, but you will still find there the three key ideas that I explained today. Mainly, his debate there, as so is Plato's, is with the guys who hold that the only way you can say that something is just and fair is as a result of a convention, be it a contract or an enactment, a legal enactment. He's fighting this and he's saying, no, there is something that is naturally right independently of what we agree, independently of what your random legislator may say. So yes, there is the danger, but at the same time, I think there is the hope.
Thank you very much for the fantastic presentation.
Thank you.
You referred to the natural law as human law. And today we had a presentation here at Cornell where they presented the first artificial intelligence law, ROS. And I've been debating in my own head whether what's going to happen to the law. Because if we want to debate what's just and what is fair, some people might argue that there is a human intrinsic part to define what is just and fair. But some others might say that it's fair what the law says it's fair. So I just would like to know your thoughts about artificial intelligence softwares interpreting or even developing law.
Yeah. Well, I hope not to disappoint you very much, but all I know about artificial intelligence is Her, the movie with Joaquin Phoenix and Scarlett Johansson. Maybe another one called Artificial Intelligence, but I don't think I've seen it, by Steven Spielberg. So I don't know. I have no idea. I don't know what to say to that. Perhaps you have another question.
No.
Or maybe you have an answer.
No, I would love to.
Yeah.
I would love to.
I don't know. Does it even exist? I don't know.
It does. It is pretending to be software.
Yeah, but there's the matter of names. You can call it intelligence. I don't know. I'm just being skeptic.
One question I have is, you really seem to compare relativism or moral relativism with natural law, inherent rights. I actually agree with that moral relativism actually almost loses its coherence at some level, as opposed to a value like tolerance, which it may be. But I think my question is more a little more sophisticated moral relativism. Say, in this place and time, the correct, the right, the just thing might be this. Whereas in another place or time, it might be that you're probably better than me at coming up with examples, which can actually be cast as that's a universal. But the universal depends on if you see situation 1, 2, 3,
Yeah.
then the morally just thing is this. If you see, 4, 5, and 6, there's a different outcome. Is that moral relativism, or is that, in contrast?
Thank you. I think it's contrast. I think it's not moral relativism. I think an important part of what I've said is that most of what there is in law and in legal system is relative indeed, and it's contingent and variable, and you will have some fundamental principles that will be the same, but the concretization will definitely vary. And of course the disagreement will come when you go down to policy things and even interpreting the law about some very controversial issues that for some will be part of what is universal and for some will be part of what is contingent. But that's a different story. That's a story that has more to do with what's the substance of this natural law morality. My argument here was a meta-claim that if you embrace relativism, then all your enterprise falls. If you don't accept that there are some, at least, universal moral truths.
Can I ask you as a possible follow-up? Take slavery.
Yes.
Which many thinkers, you'll know Aristotle and Plato better than I did,
Well,
did not view that as inherently evil at all times, and certainly it's a major part of human history. is the abolition of slavery or non-slavery part of natural law? And if so, is that a counterexample to the universality over time?
It is not. It is a counterexample to sociological universality, not to normative. Indeed, not only was slavery considered morally acceptable during some times, it was, by some authors, called part of natural law. But that was a sheer mistake. So a problem, an unavoidable problem with morality is that you can get it wrong. And I can get it wrong, and we can all get it wrong. But that something has been called morally right or part of natural law, as slavery, for example, doesn't make it right or part of natural law. It's, again, we go back to the question of names, and we go back to this possibility that even without artificial intelligence, we can get to know better. But of course, we can also get to know worse. So this doesn't solve the problem.